morning, everyone. My name is Cedric Dawkins. Welcome to the premiere episode of Season 2 of Palm Trees and Politics. Here we like to discuss hot button issues, speak with important dignitaries in the community, elected and non-elected, just to talk about things that concern you and the community. Today we have with us State Representative Christopher Benjamin from District 107. Good afternoon, Chris.
Good afternoon. Good afternoon. Thank you for having me.
Thank you for coming. Thank you for coming. So let's talk about this most recent legislative session, which has been a real whirlwind of just all kind of stuff going on. It's just crazy. So we're going to kind of get into that. But first, let's start off with, tell us where is District 107? Who exactly do you represent in the community?
District 107 is approximately half of Miami Gardens and all of North Miami Beach, and then a sliver of North Miami.
Okay.
And then, of course, some unincorporated areas of Miami-Dade County.
Okay. Very well represented areas and very highly populated areas as well. That's great to know. So let's get into the session. So first, let's talk about the good things that happened, which from my understanding, there weren't that many of them, but we're going to get into those. I know you were able to pass a bill called the Good Daddy Act, I believe.
Yes.
So let's talk about the Good Daddy Act.
Okay. It's HB 775.
Okay.
And basically what that bill does is that it puts unwed mothers and fathers on even playing field.
Okay.
And so prior to this bill passing, any child who was born out of wedlock, the law said that the mother was the natural guardian of that child.
Okay.
And therefore, as it relates to issues of custody and parental responsibility, the mother was looked to for that. And the father had to actually go to court and have a court declare paternity and then assign him his parental rights that really are his rights by birth of the child.
So even if the father was on the birth certificate, he still had to go to court to obtain custody.
To establish his parental rights.
His parental rights.
Period. So, and it was interesting because if he had stepped up and voluntarily acknowledged paternity, they'll assign him child support.
Wow.
But in order for him to get any of his other rights as a father, he had to spend the money, go to family court, and ask the court to recognize him as the legal father of the child and therefore then assign him the rights of a parent. So what HB 775 does, or the Good Daddy Bill, what it does is it says now when a father steps up and they voluntarily acknowledges paternity, that he is now the natural guardian of the child along with the mother. So all the rights and obligations of parenthood now belong to both parents, the mother and the father. So that if any disagree as paternity, no, well, not paternity, but if any disagree as it relates to time sharing, as it relates to shared parental responsibility, if there's a disagreement with those things, now they got to go to court.
So now, what's the difference in the, I guess, the execution of that, whether between a married couple and just say, girlfriend, boyfriend with a child?
See, it gives that unwed father the same rights as a wedded father. So he can go to the school and say, let me see the records. I'm on the birth certificate, I'm the dad, let me see the records. He can go to the hospital and say, let me see the records. He can say with the mom, listen, we need to go send him to this school, or we need to let him play this sport, or her play this sport. And only when they disagree do they now have to go to court. And there used to be a time when if they were co-parenting without any court intervention, and they were co-parenting, child's with dad for the weekend, they've agreed, and mom gets upset with dad during the weekend and says, bring the kid back. Dad says, no, we agreed that he was going to be with me for the weekend, I'm not going to bring him back. Next thing you know, dad gets a knock on the door, it's the police saying, mom said that you won't get the kid back. Now, there's two sets of cops in that particular situation. There was one who will say, you know what, this is a civil matter, and we're not going to get involved. You guys go to court, take care of it, which was always the correct one. Okay. But there was sometimes a police officer would say, okay, do you have a time-sharing order that says you are supposed to have the kid at this time? And if the dad couldn't produce one, And the court would say, then you got to give the child back to the mom because prior to this bill, she's the natural guardian of the child.
Wow. So is there a like an order or a paper that the father that he's supposed to have on hand in case of those types of things?
Nothing other than the birth certificate that shows that he's the parent of the child. And now he can get it because he'll appear on the birth certificate of the child.
So,
and the father always had the right or the ability to voluntarily acknowledge paternity. We're not changing the process by which paternity is acknowledged. We're not changing that process. We're just saying that when he does, he's now the father for rights and the obligations. So yeah, you can go get him for child support. You can go to court and get him for child support because paternity has been established.
Right.
But now his rights as a father has been established too. So he gets to say, hey, well, I'm entitled to have possession of the child too. You know, so if the child's with me, you can't order me to give you the child back if you can't do that. Now you have to go to court.
So what happens in, I've heard of so many instances where, like how you were saying, the father takes the child or even the mother takes the child and they don't want to bring them back. How does this bill,
And that situation was always a difficult situation. Even if you were married and you were getting a divorce and mom all of a sudden takes off with the kid, you know, there are laws that are in place that will help you retrieve the child. Without, in terms of paternity issues, if paternity had not been established yet, you couldn't get, the court wouldn't intervene. If you didn't have a time sharing order established yet, the court couldn't order her to bring the child back. You can determine paternity still and all of the things incident to paternity, but the court couldn't order her to bring the child back or order her not to move.
well, I guess in terms of custody in court, a lot of times it just seems like they kind of always just automatically award the child to the mother. Does this help the fathers if in the event, nothing against the mothers, but say the father was a little more stable financially, just stable in a lot of different ways, that gives them a greater consideration?
Now, this bill deals with unwed fathers and putting them on an even playing field.
Okay.
And it also presumes that once rights have been established, that the two parents can co-parent together without issues. And now, if there are going to be issues, both of you go to court. So now what happens when you go to court is basically what your question is asking me, is what happens when you go to court. So now there's a new bill, there's another law that passed this session, I believe it's 1031, which basically says that when we're looking at time sharing between the parents now, because we no longer call it custody in the state of Florida. Years ago, we dropped the custody thing, we call it time sharing. So in Florida, when we look at time sharing, we say 50-50, that 50-50 is in the best interest of the child. And whatever parent wants more than 50%, then they have to make an argument to the court as to why they should get more than 50%.
Oh, okay.
Now, we used to say that, listen, both parents come into court on equal grounds and that they both have an equal right to the child. But it didn't always play out that way, right? And so what this law does is it clarifies and it confirms that sentiment that now when you guys come into court, where it is presumed that you're both good parents and you both are wanting to be in the child's life, and it's in the best interest of the child to have you in the child's life and for you guys to rear this child together. And so there's a presumption now. It's a rebuttable presumption. Again, you can present some evidence to overcome the presumption, but the rebuttable presumption is that 50-50 is in the best interest of the child, and you tell the court why it's not.
So pretty much each parent gets benefit of the doubt from the outset.
From the outset.
And it's up to, I guess, the mother
or
to
the
prove,
father,
or father to prove that the other one is less fit or what have you.
Or that it's in the best interest of the child that parent get more time sharing than the other parent.
Now, how, in terms of child support, how does that bill affect that in any way in terms of determination?
Sure it does. Because the way child support is calculated now is that it takes in consideration how much time the child is spending with each parent within that calculation. So if each parent has the child 50% of the time, and so it would be presumed that each parent then foots the expenses of the child when they're with that particular parent, except in the instance in where there is a uneven, or we say there's inequity in the amount of money that one parent makes over the other parent. And then within the guidelines and then within the calculation guidelines that we currently have, the parent that earns more may see him or herself having to give something to the other parent. But it's not as much as it would have been in our current scenario where you had less than 50% child time sharing.
So now with, is there I've heard of situations, but I can't recall if they're in Florida, where say if the woman makes more money, is she ever ordered to pay child support to the male?
Yeah,
if they have 50-50 or?
Yeah, because the way that child support works is that it's a mathematical equation. And then that mathematical equation uses both parents' income to determine child support. And each parent technically within the guidelines has a child support amount that's attributed to them based on the percentage that they have of the combined net income. So, maybe dad's income is 60% of the combined net income, and maybe mom's is 40% of the combined net income. So their responsibility for child support reflects that 60 and 40%.
Oh, I see.
It just so happens that the parent who has the greater amount of time sharing is the parent who receives that obligation from the other parent.
But if they have 50-50, then how is that calculated?
And they have the 50-50 and they have income that are close to one another, then you could see a lot of situations in where there's no child support being ordered to be paid by any of the parents.
So now you mentioned a lot about the father stepping up and acknowledging paternity. Give us an example, just outside of course, a signature on the birth certificate. How do you mean? How would they acknowledge? And
that's how that's how you acknowledge people. That's how the old folks used to say it. Did you go sign the birth certificate?
Right.
But that's not what really happens. What happens is that if you're in a hospital and you're not married to the mom, they're going to bring out a form that's called acknowledgement of paternity, and you're going to sign that acknowledgement of paternity, saying yes, this is my child, and mom signs it too, saying yes, this is the father of the child, and then they send that into vital statistics, and I believe you have 60 to 90 days. I'm going to say it's 60 days to say that to take it back, and after that, you're the dad. Legally, you're the dad.
But that helps them all the way down the road.
It didn't before, not before the bill. But now since the governor has signed, we passed it and the governor has signed it, now it does. Now it truly establishes that person as the father of the child, both legally and morally.
Dads, that's great news for you all. So make sure you acknowledge your paternity, step up to the plate so you get all your rights. Now, we're not going to, continue to beat that drum. We want to move on to some other good things that may have happened during this session that people may not know about.
Sure. Since we're on the topic of kids,
yes.
We now have a permanent tax break as relates to Pampers, and for our seniors who may go through issues with incontinence, those adult Pampers or diapers,
like the Depends, things like that.
Depends and stuff like that. There's now a permanent tax break on those things, and we had a complete tax break package that we offer. Typically, each session there's some type of tax breaks that comes up, such like gas stoves. They're typically temporary ones, but this one's going to be permanent.
So how would the
last session we gave tax breaks in this category, but it was temporary. It was only for a year. Now it's a permanent break.
So now what types of things that they had to present to their tax preparer to get those credits? They had to collect receipts all year, or they just give an estimate?
I think they get it I want to say that they get it at the point of purchase.
Oh.
Yeah, it's sales tax.
So they don't. Oh, so they don't pay sales tax on when they buy those things.
Yes.
Oh, not like I was thinking it's something where they.
No. You
Calculate
think
their
about
expense
tax
all year.
credits. Yeah, you think about tax credits. Yeah, no, these are tax breaks. These are point of sale tax breaks.
And so the retailers are.
Yeah, are set up to know that these things are tax free.
Oh, that's good. That makes it easier on the consumer.
Yeah.
Very good, very good. Well, these have been some very, very interesting items that we've discussed with State Representative Christopher Benjamin. After the break, we're going to get into the dark side of the legislative session, which was pretty dark, but we'll get into that. And we'll be back on the other side of the break. This is Cedric Dawkins, and you're watching Palm Trees and Politics, Season 2. We are back. I am Cedric Dawkins, and we're here in the premiere of Season 2 of Palm Trees and Politics. With us today, we have State Representative, District 107, Christopher Benjamin. Welcome back.
Thank you.
And before the break, we were talking about the good things that passed during this past legislative session. Unfortunately, now we have to kind of go to the dark side and talk about some of the bad things that happened during the session. We have a graphic up of 10 bills that were identified kind of as bad bills that were passed during the session. So we're going to just run through them right quick. And Representative Benjamin will just kind of give us some insight into these bills and, what's bad about them, and then what could have been good about them had they passed. So first we have the HB 1417, the rent control ban. Tell us a little bit about that bill.
And this portion of the bill, this bill had a lot of other things in it that would have been good without this part in it. Mm-hmm. And so the bad thing about this is that it does away with some local protections that some counties have enacted for their tenants within their county, such as Miami-Dade County. We enacted a tenants bill of rights, and now with the passing of this bill and the signing by the governor, that those tenants bill of rights for Miami-Dade County no longer exist.
Oh, wow.
You had areas like Orlando and Orange County who passed actual rent control and similar tenant bill of rights types of ordinances. And so now those things are all now done away with. And it's bad because, as a political scientist, we're taught that that government closest to the people are best for the people because they are there, they understand the people's issues, and they're there to give immediate relief to the people. Right. And though people in Orlando came to their government, to their local government, and said we needed some relief, and that local government enacted some relief that was good for Orange County. And Dade County did the same thing. Dade County listened to the people and heard people say, listen, these landlords are not being fair with us. And we need something to even the playing field. And Dade County crafted something that they thought would help in that particular situation, in these particular situations. And then we, the state, now comes and say, you know what, we think we know what's best. Right. And we don't want you guys no longer doing these things. And so this bill preempts the local government from. So a
landlord in the middle of the lease can just up the rent, or does the landlord at least have to still adhere to the contractual parameters of a lease, a residential lease?
They have to still adhere to the contractual parameters of the lease. You can't up the lease, within the lease period. But most leases are 12 months, and most people stay in their spaces for more than 12 months. And so
right, but I've heard so many cases of the rent was $1,900, but as soon as that 12-month hits, boom, now we're going to 26.
Right.
Take it or leave it, type of thing. And so this bill, there's nothing really that
nothing
can
that
be done.
The local government can do about it. And so now you have an instance where the local government can't do anything about it, and the state government doesn't do anything about it. And in this inflationary time, with these rents just going sky high, that's not good news. No,
not good news at all.
I mean, rent itself is high because property values have gone up, so rent has gone up. And in addition to rent going up, we all know what's going on with insurance. Insurances have gone up. We're losing more carriers now.
Yeah, I just saw that Farmers.
Farmers has left the market now, so that means we have less people providing insurance within the state of Florida. And this was the bills and all the special sessions that we had that was supposed to deal with reforming our insurance industry was to boost competition, to ask people to come into Florida and say, listen, we provided an environment that is conducive to you guys doing business here in Florida. Come on back to Florida. Now we see people are actually leaving the state.
Right. Because we've had some, I feel, it's because we've had some bad weather. They finally had to pay out a time or two. Now they're upset. They want to leave.
Yeah, I mean, and listen, even before the legislation that was passed, we had insurance companies who were going under here in the state of Florida.
Wow.
You know.
Wow. Well, there's a whole lot more we can say about that, but we're going to move on to HB 1403, operating on religion. Now, tell us a little bit about that.
This basically gives doctors who object to a particular type of care that they say doing that particular type of care for you may violates their religious rights, that their religion tells them that they shouldn't be doing it, so they don't want to be able to be forced to have to do something that their religion says that they don't do, which is problematic in and of itself in the healthcare. And we had a couple of doctors that are part of the legislature. We have a couple of medical doctors that are part of the legislature. And my thing to them is that, one, you have a Hippocratic oath. And on top of a Hippocratic oath is that if you're not in it, the medicine, to heal and help people regardless of who they are, regardless of who they may choose to love, or regardless of who they are as a person, who they say they are as a person, then you shouldn't be a doctor. If you're not willing to treat people, you shouldn't be a doctor. But we had some, what happened, the basis behind this, what they gave us the basis behind this is that you had some doctors who spoke out during COVID and basically said things about what the COVID wasn't, and they felt like they were silenced, you know. And that's the whole thing with the conservative right, is that a lot of these bills or a lot of things that they're doing now in states to where they hold the majority is because they're saying that they're being silenced in other areas and they're not being listened to. And so this bill kind of does that for doctors. It says that, you know, if you have a religious objection to a particular care, then that you don't have to, and you can't be, or you can speak out. Really, it says you can speak out about care, or you can speak out about a particular social issue, and you not be called up by your boards and be disciplined by your boards, or be suspend your license being suspended or something because of a particular viewpoint that you may have.
So, like, I know certain religions and faiths don't believe in blood transfusions, things of that nature. So is that something? So does this bill so say if the doctor was in one of those faiths or religions, that gives him the right to refuse that treatment to the patient, or?
And let me be honest, I don't know what they mean when this graph says that it gives doctors permission to deny life-saving care on the basis of personal religious beliefs, because you can't refuse. Like, if you go to the emergency room, a doctor can't refuse to save your life. A doctor can't refuse to do that. For an adult now, an adult can refuse a blood transfusion because of religious practices, but not for a child.
Okay.
You know, so there's a give and take. So from my understanding, where that bill came from is what I told you, is that doctors were speaking out against certain maybe gender affirming care and things like that, and they were being disciplined by their medical boards and stuff like that, and
maybe mask mandate type things.
And mask mandates and things of that nature, PPPs and all that stuff. And they said, you know, we have the right to speak out and as to what we believe and how we see how what we believe affects our practice of medicine, and we shouldn't be punished for that. And so that's kind of where this comes from. But again, is it really much to do about nothing, right? is your ability to practice medicine really being affected by what's happening socially? And if you're not willing to save someone's life because you disagree with their life choices, then you shouldn't be a doctor.
Right. Because your oath kind of supersedes all of that.
Right.
All
You
of
should.
that.
Right.
That makes sense.
If you're not willing
makes
to give
sense.
life-saving care, you shouldn't be a doctor.
Makes sense. Well, as we move on to SB 1616, concealing corruption. This is, I don't know, kind of crazy to me. Changes sunshine laws to allow the governor to avoid public disclosure and hide travel records. Well, what is the purpose of that? Does that bill only protect the governor? Or are all politicians now do not have to disclose certain things? What exactly?
I think this particularly went to the travel plans of the governor. Now, the Republicans saying that it was about safety, that this law was about protecting the governor's safety when he's traveling about and things of that nature. But it protects record. It also protects the records after he's already traveled. Like, you can't get them after he's already traveled.
Wow.
It is.
But it doesn't help other politicians. They still have to disclose their stuff.
Right. You know, so it was something that was crafted just for the governor, and because of what he's doing campaigning, how the governor's campaigning, they're just trying to cover up how money's being spent on travel, and so.
Wow.
They came up with this, and because they have the numbers that they have, they can pass ridiculous bills like that. That makes no sense.
Because I'm
if
sure
the governor's
that bill,
already traveled,
I'm sure that went on party lines in terms of the vote.
Absolutely, because if the governor's already traveled, what sense does it make to exempt them that travel record from public records? If he's already traveled.
Right, if it's after the fact.
If it's after the fact, why exempt that? But this law would say that record also is exempt from public record and can't be revealed.
Wow. Well, on that same vein, SB 266, censoring academic freedom. Now, is this the bill that where the diversity, equity, inclusion programs have been just canceled across the state and colleges?
In state-ran schools, yes. This is the bill that does away with diversity. The DEI departments or any spending, that's what it does. It does away with any spending on DEI programming within the state colleges and universities.
I've just been trying to figure out what is the fear of diversity, equity, and inclusion. It was created to make sure everyone is on the same plane, and now you're saying, no, go back to people being uneven.
Well, it's part of the attack on this pushback on systematic racism or systematic inequities within our system. There's a pushback by the conservative right that these things no longer exist. That we're entering to, or we have entered into a colorblind society, and that DEI programming has become a litmus test as to how woke you were. They like to use that. They like to use that terminology. But we know, as the originators of that terminology, woke meant being aware of political ramifications, being aware of systematic oppressions, and being aware of how your rights are being impacted. They now want to make that a dirty word or a dirty thing. In my opinion, what I believe the reason it is because we've come upon a generation who are more socially aware and more socially inclusive.
Yes.
And they don't want I believe that they don't want us to enter into a period where you have a generation that truly is willing to let people live and let live.
Right.
They're willing to say you live your life however you want to live your life, and I don't encroach upon that, and I support you. You know, if it doesn't speak to their values, they feel like this is an attack on their values, because there's a generation that are saying, you know, we're willing to call people by the pronouns that they want to be called by, that we are willing to acknowledge that Black folks have been oppressed for years in this country, and truly there's never been any real ramification. There's really been no real addressing or redressing of the ills that have come from that oppression. And so we're entering to a society where younger generations are now saying, you know, we acknowledge these things, and we're willing to not be racist. We're willing to do more. We're willing to be anti-racist.
Right.
You know, and I think what you're seeing is a quailing. It's an attempt to quail that type of societal growth.
And then by using the term, I said, oh, we're the most free state. What do you mean by free?
And what they're really talking about, and let's be honest, what they're talking about is a augmenting or a confirming or solidifying of traditional values or traditional norms, you know, and they don't want to move away from traditional norms. They see that as a bad thing, that as people come out of the closet, as people tell you who they are, they want to push back against that, and they push back against that by saying that this is something that is not normal, that this is something that that we shouldn't accept as normal.
That's a lot. And that does the book banning fall under this as well?
Not under this particular bill,
Okay.
but this one does do away with critical race theory being taught in primary courses, which it was never taught in primary
Right,
courses.
that was my understanding.
It was never taught in primary courses. It was never taught K through 12. CRT has always been and continues to be a law school elective, which means it's a graduate level course taken as an elective. That's what it's been, and that's what it's always been, and that's what it is today. But it's the boogeyman, so they made it the boogeyman.
Make it seem like it's something
that it's being taught everywhere in our system, where it's an elective course. There are so many black folks who have graduated from law school and have never taken a course in CRT.
Right.
You know.
Wow. And then we have SB 256, union busting, targeting public workers, cripples unions, preventing collecting dues automatically.
Yeah, and this is the bill that calls for continued recertification. This is the bill that says if you fall below a certain percentage, I believe it's 50%, that you have to recertify the union. And then this is also the bill that says, you know what, if you are a union member and you want them to take your dues out of your check, you are no longer be allowed to have them take the dues from your
Even if the employee wants that,
even if the employee wants it, because it was always voluntary.
Yeah.
Payroll deductions have always been voluntary.
Right.
It's something that an employee goes to their employer and says, can you take this amount of money out of my check every month? Maybe I got a savings account. Can you divert some of my income to this particular account? It's the same. It's of the same nature, you know. And so it made no sense. It made no sense when they tried to do it last session. It makes no sense when they did it this session, that someone can't have the ease and the convenience of having a payroll deduction.
So now, for instance, the UTD, which is huge, United Teachers of Dade. So all these teachers had to write a check every month to UTD.
Yep.
As opposed to
just having it taken out of their paycheck.
So I guess as I'm thinking, maybe an alternative, they had to do it through their bank account, maybe.
You have bill pay. You have bill pay on your accounts. We're not saying that there aren't other means by which an employee can get their dues to the union. What we're saying is that why take away an ease and comfort that they've had for years, just to make it more difficult to continue to have dues paying members, so that now, because you didn't do it, because now I've been used to you taking it out of my check. Now you stop taking it out of my check, and I forget. Oh my God, I got to write them a check, or I got to get this money to them every month. Now your paid membership drops, and now you're all over again. You got to recertify.
Now, at what time period do they measure?
And I believe they got to do it every year. If I'm not
Every
mistaken,
every calendar year.
I think they have to do it every year.
That's crazy. Well, and we don't have it on the screen yet. We will in just a moment. The other half of the bad bills, just from memory, let's skip to the open carry bill.
There you go.
Oh, it's right there. HB 543, permitless carry. Now, this has caused a lot of anxiety in the community and confusion. What are the rights of the gun carrier, and should the community be afraid?
Here's why many believe that this bill is problematic. Is because they believe that those folks who didn't bother to go get a
permit.
permit before, and for whatever reason they didn't bother getting a permit. Like, they were legally able to do it, they just didn't bother to go do it. That kept guns out of the public.
Right.
Now, because you don't have to have it anymore, you know, and like I said, for whatever reason people didn't do it. Maybe they didn't want to bother with taking the course. Maybe they didn't want to pay the $98 that it cost to get it done. I have mine. I'm a card carrying member. I believe in carrying firearms for protection. I'm a military veteran, so I believe in using firearms for protection. But what this does, it says that, you know, if you're legally allowed to carry a firearm, that you can now carry your firearm in the public concealed without the permit. And what a lot of folks who are against the bill says that, well, in getting the permit, you had to show that you had some type of training with it, with a firearm, which means that you know the safety, you've learned some safety guidelines with regards to how you carry a firearm. You've learned how to shoot the firearm properly. So they're saying that now those things are gone, so that anybody who is eligible to purchase a firearm can now carry that firearm on them in public as long as it's concealed.
And with no training, they haven't been to a single class.
Nothing.
They don't even know how to engage the safety or disengage the safety.
They can carry a firearm concealed.
Wow. But now I did see that like restaurants and certain businesses can say, we don't want a weapon, concealed or not.
Concealed or not. Yes.
On our
Business owners are still able, because remember, we're all just invitees to the business. We're public invitees to the business. So every business owner can say, you know what, in here, we're a gun-free zone. So you can't bring, you know, no shirt, no shoes, or guns, no service.
Right. Well, that's a good thing. I would say that's a good thing. That the SB 1718, the anti-immigrant law. Now, what are some of the components of that? Because I've seen these pictures on Instagram showing construction sites empty now because all the workers are afraid that people are going to come through there looking for them.
And that's part of the that's due to the E-Verify portion of this particular bill. And E-Verify is basically a system that requires employees to verify and confirm that the employees that they're hiring are not undocumented immigrants. And so now if you have more than 25 employees, you're required to E-Verify all your employees, and then there's a series of fines and penalties if you don't do that for the employer. And so for those employers who may have employees who may be problematic, they're seeing those employees leave.
But what about like down south? You have a lot of farmland and
a lot of those folks come in on
things of
visas.
that nature. I mean, they kind of like need those types of workers.
And a lot of those workers, and I would probably say the majority. I've spoken to a lot of immigration attorneys, and there are visas that most of those folks are on. Most of those folks aren't what we quote unquote illegal immigrants. They are visa immigrants. They're here legally. They're working legally, but they may have family members that are not.
So what's the obligation of the employer to do what? To report them? To call the Homeland Security on them?
To not employ them.
Wow.
That's the thing for the employer is to not employ them. But this bill also, like in the state of Florida, we don't give driver's licenses or IDs to undocumented immigrants.
Correct.
But some states do.
I've heard about that.
Some states do, and they do it for all the reasons why you should. Public safety, making sure that people who are driving on our roads are properly licensed, no matter what their particular status may be. So a host of reasons why giving them.
And they have some sort of proper identification.
Proper identifications that they go to the hospitals or there's some other benefit that they need to have a proper identification for. It allows them to have that. Well, if you come to the state of Florida, that ID that was issued by that other state, even because most of those states who do issue those type of IDs to undocumented immigrants, they'll tell you on on the document itself that this is not for federal purposes. Like this is not a federally accepted ID. And when it does that, when you come to the state of Florida with that, and you're driving, you're now driving in the state of Florida illegally.
Oh, wow.
Yeah, and you're now driving in the state of Florida illegally.
That's a lot.
Also, you can't leave the state. So let's say you're undocumented you're undocumented and you're here in the state of Florida, and you decide to go visit a relative in another state, and then you want to come back to the state of Florida, and you're with other family members who maybe are citizens. You know, your kid, maybe it's your kid, and your kid's an adult, and they're driving you back across the state line. Now your kid is a criminal. Your kid can be charged criminally with bringing you across the state line as an undocumented immigrant.
Wow.
Yeah.
Wow. Now this, of course, is the biggest one of all, SB 300, the abortion ban. So it says bans abortion after 6 weeks with unworkable exceptions. So unworkable exceptions, I'm hoping, are things maybe like rape, incest, things of those nature. Are those things?
The problem with, so this ban, what they will tell you is that this ban comes with the normal exceptions: rape, incest, sexual trafficking, things of that nature, right? But even with rape, now you got to report it. You got to have evidence of some type of evidence of the rape in order to be able to to do that. And this bill will go into effect after the Florida Supreme Court case deals with our 15-week ban.
Oh, okay.
Because we did a 15-week ban last session, we did a 15-week ban, and that was challenged based upon Florida's privacy laws. So we have privacy laws greater than the federal privacy laws, and so.
So does that make them enforceable?
Because what they said, what the Supreme Court said, basically in overturning Roe v. Wade, is that abortion is not part of the gambit of federally protected privacy rights. But Florida, they're arguing here in our Florida case that Florida does have such a greater privacy rights that abortion falls within that caveat of privacy rights, and so it should have the same effect as Roe v. Wade here in the state of because of our state constitution. Our state constitution should give us the effect of a Roe v. Wade. So we're waiting to see what the Florida Supreme Court says about that argument. Does our state constitution that gives greater privacy rights than our federal constitution, does that include the right to an abortion?
Oh, wow.
So if the 15-week ban gets stricken by our Florida Supreme Court, which we have a conservative Florida Supreme Court, but if it does get stricken, then that means that this abortion ban is unconstitutional as well. If it passes, if the Supreme Court doesn't strike that 15-week ban, then this 6-week ban goes into effect.
So a lot at stake, HB 1069, Don't Say Gay Part 2. Now this is what I was asking about, the promoting of book bans, limiting curriculum, prohibits use of preferred pronouns.
Right, and that does exactly what it says. Although we're saying that it promotes book bans, in actuality, it puts some guardrails on the book bans that we initiated last session. So last session's legislation created the opportunity for book banning, and it basically said that once a book was banned, it basically couldn't be challenged.
Wow.
So this bill now says that you can challenge the outcome of a book banning, but it still lifts up the whole idea of book reviews and books being
yes,
banned.
but like for instance, the book with Amanda Gorman's poem in it, one parent in Miami Lakes, I believe, said she thought it was whatever she thought it was.
Right.
And then the school board votes to just abolish the whole book with the poem in it. That is crazy. One parent.
And that's the thing, is that what this bill does, it makes the process something that each of the 67 school districts have to implement on their own. Like, you can have 67 different policies on how books are reviewed.
Okay.
because there's 67 school districts.
Right.
So Dade County, because it was coming out of a school in Dade County. So
Yes.
Miami-Dade County
Yes.
School Board has to determine what's the process by which we review books or we allow books to be reviewed. And prior to their school board meeting that addressed the issue, prior to that meeting, the schools themselves were reviewing the books and determining what they were going to do with the books. And most of the time, the school board didn't even know, or the district didn't even know what happened at that school with that particular thing.
Because I know I have a friend whose mother used to work with the textbook curriculum, and she used to fly to different conventions around and help choose books and things of that nature. But now it just seems like, you have these people who just nitpicking for just any little thing. And I don't understand. I've heard that, if the African American history being taught makes others feel uncomfortable, then it should be removed. It's history. You can't change that.
And that's not what the ban or the review was about. The review was supposed to be about sexually explicit material and inappropriate grade level material. That's what they're supposed to be reviewing. But just like anything that doesn't have proper parameters or proper guidelines,
It just ends up all over the place.
it ends up all over the place. And so that's what we're seeing now, is that these things are ending up all over the place. But the legislation does provide a mechanism by which you can challenge the outcome of a particular ban. Again,
As
it's
an
up to the
individual, they had
district.
to band together with several parents or a
No,
PTA.
just like one individual causes it to be reviewed, an individual can cause that decision to be reviewed, which we may not want that to be the case. Again, this is controlled by the school district. The school district controls the process by which these books are reviewed.
So does this does it remove the school district's what I want to say, their allowance to be able to say this book goes, this book stays?
No.
They have to go by the state
No,
mandate, or they still have authorization to
They can
make their own decisions?
They can say that a book has been called up to be reviewed, and they can make the decision that there's nothing wrong with this book. We're keeping the book where it's at. There's nothing wrong with the book. Now, before, that decision was final. Couldn't be challenged.
Okay.
But now that decision can be challenged.
Okay.
So a parent can challenge that decision.
Okay. Makes sense. So now the last one we have here is the death penalty. So to my understanding, at one point it had to be all the jurors had to agree for the defendant to get the death penalty, and so now that's not the case?
Right, and there are different phases to a death penalty trial. So the part where a jury is determining whether the death penalty is appropriate is after they determine that the defendant is guilty of the charge that they've been accused of.
Okay.
So that is still unanimous.
Okay.
So a jury has unanimously decided that this person is guilty. Now they have to determine, are there enough aggravating factors of how this crime was conducted that they should issue the death penalty.
Yes.
Now before, that decision had to be unanimous too. So you had a unanimous decision for guilt, and then you have a unanimous decision for the death penalty. So the unanimous decision for guilt is still there, but there's no longer a unanimous decision as it relates to the death penalty. Now, those who promulgated this particular legislation said that we want to do away with unjust effects, like the Parkland shooter, I believe. They determined that they couldn't get a unanimous decision as to the death penalty. So a situation where someone should be people feel that should be put to death.
Right.
They're not put to death because you can't come to a unanimous decision about the death penalty phase of the trial. So this particular bill says you no longer have to come to a unanimous decision about the death penalty phase.
Okay.
And some people still think that that's wrong too, that you should still have unanimous decision, unanimity on both sides for finding of guilt and for determination as to whether the death penalty should be applied. They both should be unanimous.
So now, even if the person is found guilty unanimous, There still has to be another.
There's another phase of the trial
right, okay.
to determine whether the death penalty will apply in this.
So it
particular
doesn't
instance.
automatically shift you over to eligible for death penalty if you're found, unanimously guilty.
Right. If you're found unanimously guilty of a crime that's eligible for the death penalty, then the court looks to the jury now to determine should we do it in this particular case. And then there's a vote taken. The jury takes a vote, and in order for the death penalty to be applied, that jury has to unanimously decide that it's appropriate. If they don't, then the person who's eligible for the death penalty doesn't get the death penalty because the jury couldn't unanimously decide
Decided they should have
if they should have it or not. So this bill says we're not looking for unanimity anymore when it comes to the penalty phase.
Right.
That if we can get the majority of the jury to agree
Right.
that this person should be put to death, then that's what we're going with.
Gotcha. Ladies and gentlemen, that is a lot to digest. Hope you're able to somehow, unpack it bill by bill to get a better understanding. We thank Representative Benjamin for breaking all that stuff down for us. Now, I have a question for Representative Benjamin. Are there any of these bills that, people will be going back next session to try to appeal, attack, amend in any way?
Listen, I
to make it more palatable?
I could foresee my Democratic colleagues may try repealer bills. It was a time in our legislature that repealer bills weren't counted against the number of policy bills that you were allowed to have. So we're, as members of the House, we have 7 policy bills that we can put forth every session. And repealer bills weren't considered part of that 7. This session, they made repealer bills count against your 7 bills. So depending on the type of bills that you want to bring or other bills that you already had in the pipeline, you may not want to take on a repealer bill to count against your 7. I didn't see any repealer bills this session, and we had a lot of bad bills last session.
Wow.
So
I guess you got to pick your battles.
got to pick your battles.
Wow, that's crazy. Well, please let the people know, especially your constituents, how can they reach Representative Christopher Benjamin?
You can reach me at my district office at the Experts Building on 183rd Street, 610 Northwest 183rd Street. You can also reach me online at christopher.benjamin@myfloridahouse.gov.
Great. We look forward to reaching out to you and speaking with you in the future to see how these things progress. We want to thank you all for tuning in. My name is Cedric Dawkins, host of Palm Trees and Politics, also president and CEO of Freeze Frame Marketing and Media. We look forward to you tuning in to us the rest of the season. We are going to have a lot more great guests, a lot of informative information, and we just want to keep you in tune to what's going on in and around you. Once again, my name is Cedric Dawkins, and this is Palm Trees and Politics. Thank you so much, and we'll see you next time. Have a great evening.